Hello, I'm Leanne Sanders. This is APTN News InFocus. On this episode, we look at the long wait for justice for people who say they were wrongfully convicted.
30 years is a long time. That's cruel and unusual punishment. And you know what? I'm going to kind of relate to even animals don't get locked up like that. You know, today I do suffer with PSD and all that stuff because, you know, sitting in prison for so many years wondering, you know, why?
That was Odelia Quewezance at a news conference in 2022 in Ottawa. She and her sister Narissa were found guilty in 1994 in the murder of Anthony Joseph Dolph, a Kamsack area farmer. It happened at his farm the previous year. A younger cousin of the two girls admitted to carrying out that killing, but the girls were also charged and convicted and served more than 30 years in prison for a crime they say they didn't commit. Here's their lawyer speaking at the same news conference.
If they were white and they'd been arrested for the murder, would they have been convicted of it? No. And if they were white and they'd been convicted of the murder, would they now be out on parole? Absolutely, for sure they would. Of course they would.
On the same day Lockyer and Odelia held their news conference, former Justice Minister David Lametti announced that their case would be reviewed by what's called the Criminal Conviction Review Group. They're lawyers who sift through a case and make a recommendation to the minister. The status of their review? It's still not completed. That's in stark contrast to the prosecution of their case, which went to court within a year of the murder that they were accused of committing. Someone who has some insight into the process joins me now. Senator Kim Pate is a passionate advocate for those who have been wrongfully convicted, especially Indigenous women. Senator Pate, when a case is actually under review, as the sisters has been, we know that there have already been hundreds of hours, maybe even thousands of hours of work by defense lawyers and advocates in even getting it before the CCRG. How do you see the length of time that it takes for a review?
Well, the length of time has been extraordinary in Canada. When I was talking to folks who do this work in New Zealand, for instance, where they also have a high Indigenous population, many more cases are reviewed within the timeframes that we've seen. Certainly, this is the first time we've had Indigenous women's cases reviewed. They're not the first to apply, which says something in and of itself. And the fact that we're now waiting 4 years on for a decision to be taken, the investigation, to my knowledge, was completed at least a few years ago. And so the obvious question is, what's taking the time for a decision to be made or to be issued by the minister?
It does seem like there's a bit of a lack of transparency with the whole process. We had inquired what stage is the review at with the group, and they couldn't tell us that. They said it was due to privacy, which I understand comes into play in a lot of cases, but it just seems like we can't get any answers from the Justice Department. And is that just my view, or does everybody have sort of the same issue with that?
Well, you can probably tell from my expression, whose privacy? I mean, presumably they mean the privacy of Odelia and Narissa Quewezance, whose review it is. And to my knowledge, in the discussions I've had with both of them, neither of them have any idea where things are at. And when they've asked their lawyers who are involved and asked their lawyers to communicate with me, they're told that, basically encourage me to ask the minister. So the reality is, the question is whose privacy is being protected. If it's the women's, they want the information out there. So it would be in a nanosecond to obtain the consent if they don't already have it, which would be a shock to me. Usually, as the investigation is undertaken, everybody who's involved consents to provide the information. So, that to me sounds like a stalling tactic as opposed to a legitimate reason why we have not received this information. Not so much me, but why they have not received the information about what's happened with the review of their files.
Right. Now, obviously, people saw some problems with an elected partisan person, namely the Justice Minister overseeing these CCRG reviews, and the new Miscarriage of Justice Commission was created. But even that commission is sort of stalled. A commissioner has not been named. What does that say, in your opinion?
Well, it tells us that a priority is not to deal with injustices. We're told that Bill C-14 and C-16, which are currently before both houses of Parliament, law reform, public safety, justice are priority issues. If that were true, then the Miscarriage of Justice Commission would be up and going right now. We wouldn't just have named that it would be in Winnipeg and no commissioner named. It would be properly resourced because the presumption is that we want to deal with these issues. Canada made a commitment in accepting the Truth and Reconciliation calls to action. Call number 30 is to end the overrepresentation of Indigenous people in prisons by last year. We obviously haven't achieved that. Miscarriages of justice and these kinds of reviews are crucial to addressing these issues because, as the Justices Harry Laforme and Juanita Westmoreland-Traore said when they asked me to pull together the cases of not just the Quewezance sisters, but 10 other women, the pattern of the abuses, the pattern of the injustices is very clear when you look at a group of cases together. It's why we suggested, with their support, that those 12 women's cases all be reviewed together. There are different fact situations for each of them, but the patterns of histories of abuse, the patterns of residential school involvement, the patterns of child welfare involvement, the patterns of them being criminalized in situations where they were taking responsibility for the behavior of other people and or responding to violence and poverty and the situations they were in are very clear in all of those cases. And so if the government was truly interested in addressing the disproportionate impact of our criminal legal system on Indigenous peoples, then presumably that not only would Odelia Narissa's case being some kind of remedy right now, but also we'd see the review of other cases unfolding.
Do you believe, you've done so much work in this area, but do you believe Indigenous women in the justice system are faring any better in 2026 than when the Quewezance sisters were convicted 32 years ago?
Sadly, no. 32 years ago, Indigenous women and men were about 11% of the federal prison population. Now women are 1 in 2, 50%, and men are over 30%, 1 in 3. So the situation is getting worse. And in large part, that's because not only are the issues within the criminal legal system, I don't call it a justice system because particularly for Indigenous people, there's not much just about it. But not only have the issues not been dealt with there, but we haven't dealt with the very issues that contribute to more people being in the system, and that is the lack of supports in community, economic, social, health supports. In many First Nations communities, we know we still have boil water advisories. We know we still have inadequate housing. We know we still have inadequate access to community supports and education. And food insecurity. And so for as long as we're still dealing with those kinds of inequalities, that feeds the very system because, as I often say, the prisons are full of the people who are failed by every other system. It's not a cross-section of those who create the greatest harm or cause the greatest harm in our country. If that were true, it wouldn't be predominantly Indigenous people, and Indigenous women would not be the fastest growing prison population.
Well, Senator Kim Pate, thank you so much for your time today and for your insights on this topic. Always informative.
Thank you very much. And thank you for all the work that APTN is doing on this and so many other important issues.
The main criticism of the Criminal Conviction Review Group is that it moves at somewhat of a snail's pace. To speed it up, the federal government passed legislation to develop a new body to review cases called the Miscarriage of Justice Review Commission. But But there's a problem that was recently exposed by Kevin Donovan, the Toronto Star's chief investigative reporter. Donovan's recent article on the commission reported that after 4 years from being announced, it's still not operational. Kevin, you recently wrote a piece on the federal government's delay in getting the Miscarriage of Justice Commission going. You say in your article that you made several requests over months for information from the government. From your inquiries, did you get a good sense of what the holdup is with this commission?
Well, from what they said to me, I got 0 cents because they just gave me basically a form response. I'm sure you've seen many of those in your career. The form response was often tinkered with a little bit, but basically said that they're working on it. They're hoping to get it started as soon as possible. What I found interesting was that when I spoke to Innocence Canada, their one of their people who was there, I think he's their chairman right now, Ron Dalton, he said that his speculation is that it's a financial. This is not a time that the federal government is wanting to spend a whole lot more money. And so I put that to the spokesperson for the minister, and what I heard back was, no, that's not the issue. We can appropriate money as we need. So I think there's probably some truth to that. I think the fact that I've done a story, and presumably you have or will, might move things forward a little bit. It's very disappointing to the people who caused this to come into being, to be told, closing in on 2 years ago, that here's this new law and we're going to set this commission up, and then there's no commission set up. And I really think they've done nothing, because the people at Innocence Canada would have heard of person X being tapped to be the commissioner, and they have not heard anything.
I know some people that I've spoken with have said that the delay could be partly due to the transition in government. What do you think is behind the delays in getting it set up?
No, I think it's more likely that uh, it's not something that's going to earn politicians any votes, in my opinion. Getting people out of prison, the general public, I think, is, and this is my opinion, is pleased when people are behind bars that might uh, hurt them. And I mean, the people that have been exonerated with the work of Innocence Canada are people who were truly wrongfully convicted, and I know you're aware of some that are in the pipeline right now. So I don't think that it's anything nefarious. I think it's just not on the front burner for this government. And this government, like, it's the same color of government, it's a liberal government, but this group of people did not come up with this idea. It was Justin Trudeau's government.
From reading your article, it seems like not only is there a delay, the cases that do get referred may not be getting equal treatment by the existing CCRG. Is that your take on this?
Yeah, that's correct. The only one that I have any personal knowledge of is related to Christopher Sheriff, who is the person I've been writing about in a series over the years called Murder on Mount Olive. And Christopher, his case did go to the Miscarriage of Justice Commission, and not a full review, but a partial review. And within a couple of months, they said, no, there's nothing new here, because they were looking for new evidence. But you're quite right to point out the statistics, because there is certainly an overrepresentation of Indigenous and Black individuals incarcerated in Canada, and the statistics for the numbers that have been referred back don't reflect what you'd expect from Canada's population.
So, how do you plan on handling things going forward with the federal government when it comes to sending them questions and trying to get your questions answered?
Well, every time I do a story on the case that I am following, I will certainly mention that to the extent that that is ever noticed by anybody in Ottawa. I don't know. I Every year, Innocence Canada in October has a it's gala is the wrong word for it, but it's an event where people who have been exonerated show up, and they give talks, and I fully expect at this one this October for them to make some statements. I mean, how can they not? Because in October it'll be almost 2 years, and people are still waiting. And the government, when they did respond to me, they said, yeah, our current system is still working. They're hard at work, and I don't see the evidence of that at all. The whole idea of the Miscarriage of Justice Commission was to have an independent body to take it away from the government lawyers. So you have people who have experience with these sorts of cases in the justice system, so that they can take a fresh look at the case and see where the justice system got it wrong. In my opinion, that's not happening under the current situation. Under the new one, if they ever get it going, it probably will work a lot better. They just have to get it going.
Thanks for your reporting on this and for your time today, Kevin.
That's great. Well, thanks a lot for taking the time to talk to me today.
How is this Miscarriage of Justice Commission supposed to work? For that, I reached out to Kent Roach, Canada's foremost expert on the topic and a University of Toronto professor. He's also the author of several books, including 2023's Guilty Pleas, Imagined Crimes, and What Canada Must Do to Safeguard Justice. Kent, what was the expectation when all of the consultations and the work was all completed on the Miscarriage of Justice Act, or as it's known, the David and Joyce Milgaard Law, and it was passed in 2024?
I think first I'd like to start with the work that Justice Laforme and Westmoreland Traore did. And they worked very, very hard during 2021 in terms of public consultations. And they submitted their report, I think it was in the fall of 2021. And so there was a real expectation, I think, then that they had provided a pretty good, 225-page blueprint for what the legislation should be. And then there was lots of delay, and we didn't really see the legislation surface until about 2 years later. And there were some changes. There was some disappointment when the legislation was first introduced, the bill was first introduced. There were some changes in the House of Commons committee. And then by the time we got to the Senate, it was that kind of old story, take it or leave it. And it got through the Senate. So, you got to remember this was a time when there was a minority government. There was not an expectation that the Liberal government would be reenacted. And so it was late in 2024 that the law, the David and Joyce Milgaard law, was enacted. And so, there's obviously going to be some transition periods, but I don't think many of us thought that we would be sitting here on the first day of June in 2026 with no appointments to the new commission.
Right. So the Justice Minister's office says that they are working diligently on getting the new commission up and running, but no one has been hired yet. What do we make of that?
Well, I mean, I know things move slowly in Ottawa, but, there's a lot of other justice legislation and initiatives that have been fast tracked. So my worry is doesn't really seem to be a priority. And I also worry about the applicants who have applications outstanding to the federal minister of justice, because they're in a kind of limbo. And, one of the most important, and I think the most positive changes in the new legislation is that the standard for the commission to order a remedy is lower than the standard for the Minister of Justice. So until we get the commission up and running, it's difficult for me to see how that lower standard is actually going to be applied. The other big win, I think, in the legislation, or improvement in the legislation, is that the new commission, once it's up and running, can provide a wide variety of legal and social and economic supports to applicants if it deems it necessary. And of course, the commission can't do that if it's not up and running, if it's not appointed, and it can't do it unless it has an adequate budget. So I think in both those respects, the lower standard, which is based on a miscarriage of justice, may have occurred, and it's in the interest of justice to have a new appeal or a new trial. That's the standard the commission will apply, whereas the standard that the Minister of Justice applies is basically a miscarriage of justice likely have occurred. Now, it may not seem to you like there's a big difference between may and likely, but you have to go and pay for 3 years of expensive law school to realize that there can be a huge difference between may, which goes to possibility, and likely, which goes to a probability.
Right. And one of those was the Quewezance sisters case, which remains with that previous body, the Criminal Complaints Review Group, under the Justice Minister. And that's been 4 years now. I guess just emblematic of what has gone on previously with this body.
Yes, I mean, there have been even longer waits, I'm sorry to say, waits of up to 6 years. So, I don't want to be too harsh on blaming people, because the system is such that, that it isn't just up to the minister to make the decision. There has to be investigations when that is warranted. And then they have to present the results of their investigation to the applicant. So the applicant gets a chance to say, well, you got that wrong. But, the long and short of it is the clock is ticking. And while the clock is ticking, the applicants may be in jail, they may be out of jail, but they still have the stigma of a criminal conviction.
With everything that's kind of known now about especially Indigenous or marginalized people who are charged under the law, are wrongful convictions still happening?
Absolutely. I mean, we're never going to know the unremedied wrongful conviction, but along with Métis lawyer Amanda Carling and I, we co-founded the Canadian Registry of Wrongful Conviction. And since we've launched, I think we're working on probably about 3 or 4 or even more new remedied wrongful convictions. Obviously, the ones from Winnipeg are a good example, and we have to add them to our website and to our registry. So, wrongful convictions are still happening. And, that's why we need the commission. We need the right commissioners. We need them to have an adequate budget and a desire to inquire and, if need be, challenge in order to find out what wrongful convictions are out there but have not yet been remedied.
I know you mentioned not wanting to place the blame with any particular body or group or individual, maybe, but is there some sense that perhaps prosecutors are part of the issue?
Yes, well, I mean, certainly one of Justice Laforme and Westmoreland Traore's recommendation, and I should mention I was their research director, so maybe I have a conflict of interest, but one of their recommendations was that the commission should be able to get documents even if police or prosecutors claim legal privileges over them. And unfortunately, that was not a recommendation that is reflected in the final legislation, even though it is a power that the English Commission has. So, one of the reasons why that was recommended is that police and prosecutors in the consultation said, look, we may share some things now with the federal government lawyers who work with the Minister of Justice in the criminal case review group, but we may not necessarily have the same confidence in the commission. So yes, I mean, the prosecutor can correct a wrongful conviction, can prevent and correct a wrongful conviction quite quickly if he or she wants to, but if they dig their heels in, they are potentially a huge barrier to getting a remedy.
In your book, you explore how plea deals offered by the Crown are also a factor in some wrongful convictions, and how big of a problem is this in Canada?
Well, I mean, I reached the conclusion in my book that it's inevitable that there are going to be guilty plea wrongful convictions. And I look at the cases of 2 Indigenous people, the late Richard Catchaway from Manitoba and Mr. Clayton Boucher from Alberta. In both those cases, they were denied bail and they were given plea bargains of time served. Right. So you'd have to be almost irrational not to take that bargain, even if, as in both cases, it was later proven it was impossible for either Mr. Catchaway to have committed the crime or for Mr. Boucher to have committed the crime. So these are things that happen literally every day, every hour that the courts are open. But in many cases, we've known that Indigenous people, in part because for reasonable reasons, they often do not have faith in the system, just plead guilty. Because you also, if you plead guilty, you generally get a much better deal. You're going to spend less time in prison than if you fight and you go to trial.
Kent, I appreciate your time.
Thanks a lot.
So, what does this all mean for Indigenous people in the justice system? For that perspective, we talked to Suzanne Patles, a Mi'kmaq lawyer and member-at-large with the Indigenous Bar Association. So, Suzanne, we're just looking at the issue of the Miscarriage of Justice Commission not being up and running yet. And it's been on the books now for a while, but we still have no physical commission to speak of. There's no chief commissioner, and there are no members. And you did speak with some eloquence to me about how important this issue is for the wrongfully convicted, especially Indigenous folks who've already had so many barriers within the system itself.
I just wanted to reiterate that when we speak about justice from an Indigenous standpoint, you see something else, especially in the miscarriage of justice. You see people have been cut off from the land, language, ceremony, and community, and then punished for the symptoms of that disconnection. So that has really shaped my views on justice reform. It's convinced me that we cannot limit ourselves to small little tweaks. We need to be rethinking systems in place. So when you place the Quewezance sisters and Donald Marshall Jr. in that landscape, you see that wrongful convictions aren't random. They're a predictable outcome of a system that mistreats Indigenous people, where the systems misuse their power, and where systems refuse to see the full context of our lives as Indigenous peoples. These miscarriages of justice reveal the deepest failures of the system. In law, we talk about miscarriages of justice as cases where conviction is unsafe, where new evidence, fresh legal analysis, or systemic concerns show that, the verdict can't stand. But for a person living that reality, a miscarriage of justice is not a legal category. It takes years from their lives. It's children growing up without a parent. It's communities losing leaders, knowledge keepers, caregivers, to a system that got everything wrong. So for Indigenous people, we know that these cases aren't isolated. The Marshall Inquiry documented how racism and bias infected every stage of the process, from the investigation to his charges, to the trial and to the appeal. Other inquiries and commissions have echoed that type of pattern. And it's my hope that this commission, what right now we can consider proposed, because although it's legislated, there have been no concrete actions to really take charge of the initiative. We see similar concerns with the lack of initiative from government. And these cases all have questions about evidence, about police conduct, and about how Indigenous people are perceived and treated in the system. We need to make sure that people who have been wrongfully convicted have real pathways to review, exoneration, compensation, and real healing from the systems that have really perpetuated major harms. And this systemic accountability could use these cases to expose structural problems, because unfortunately, we don't start at a equitable beginning when it comes to dealing with any institutions. It begs to question how fast these processes go when they're not just dealing with files or numbers. These are real individuals who are facing consequences and who are still under surveillance because of inaction due to systemic barriers, because there's no other review for this type of injustice. So it's imperative that we, as not only Indigenous people, but all people, are able to feel safe in a free and democratic society. If our freedom can be taken away from us and no recourse happens if we're wrongfully convicted.
You mentioned as well in your piece that incorporating Indigenous laws is not about replacing one system with another, but I've always found it interesting that people didn't acknowledge that Indigenous peoples here already had systems of their own that worked very well. And how would that work if more of that was incorporated?
So, if Canada were to meaningfully incorporate Indigenous laws into the justice system, not just as some performative action or decoration, but as co-equal sources of law, we could see really progressive change and shifts from punishment models to more restoration models, where you would have Indigenous legal traditions where they focus on repairing relationships between the person who caused the harm and the person who's harmed, the families and the communities. And that doesn't mean there's no consequences. So, when we think of harm, that harm includes colonialism, dispossession of land and resources, and rights, and systemic violence that comes with that. So incorporating that type of lens using a two-eyed seeing approach would force the justice system to confront its own role in producing harm to peoples, and it would force more accountability. So it would also amplify the visibility of Indigenous peoples, and it would have more recognition because we would no longer be strangers to the courtroom. We still carry that. So, is the Canadian justice system willing to share space with those laws and to be reshaped by them? Is it, willing to admit where it has gone wrong? If we can really do that, then we can honor Donald Marshall's legacy. We can honor the Quewezance sisters' courage, honor the resilience of our communities, and then the commission can be more than just a bureaucratic body. It can be part of a larger movement towards truth, repair, and Indigenous legal resurgence. So, like, that's like the vision I have. I know it's large, but it's not something that's impossible. I think if anything, it's a small incremental step.
One of the things you said was regarding the training of lawyers. I had a thought yesterday that I have not personally seen very many Indigenous Crown prosecutors, and I'm just wondering if that's maybe part of the solution is to have more Indigenous lawyers seeking to be a Crown lawyer.
We need Indigenous people in all layers, not only as crowns, but as defense lawyers, as judges. We need to be in those spaces because we deserve to be in those spaces. No space should be foreign to our people. We should be able to occupy those spaces and be able to navigate those spaces with confidence. So I think that we need to be letting our people know that they're capable of being in those spaces. So it's not about whether or not we should be, it's whether or not those opportunities are available to our people.
Well, Suzanne, thank you so much for your time today and your insights into this topic. It is a huge, huge area that needs to be addressed. Senator Kim Pate called it a legal system, not a justice system, and I think that's a fairly accurate assessment.
I want to just, hand it to the Miscarriage of Justice Canada for their advocacy. And, as said in one of their documents, justice delayed is justice denied. But as I said, what I written, it's not just the complete removal of their dignity. It's far more than just denied. It's far more than that. It's stripped completely. So it's something that we can't take lightly. And I hope that we're able to move forward with, the advocacy of people like Senator Pate, who is really advocating in spaces where most people who advocate on these issues could not reach.
Well, Suzanne, again, thank you so much for your time today. I do appreciate it.
Thank you.
You can find our archive on the Quewezance Sisters online at aptnnews.ca, as well as my latest story on their case and updates on the Miscarriage of Justice Commission. This episode of In Focus was produced by Mark Blackburn and edited by Jesse Andrushko. Charmaine Straker is executive producer of APTN News InFocus. If you're enjoying the show, let us know by leaving a rating and a review. And if you have any ideas or comments, email us at infocus@aptn.ca. I'm Leanne Sanders. Thanks for listening.
Incidents and negative interactions between security guards and civilians seem to be becoming more common these days. It has us wondering, what are the actual responsibilities and powers of security guards, and why do these incidents keep happening? I'm Savannah Kelly. Join me and my co-host Jesse Andrushko on APTN News Answers, a new series where we shed light on topics related to current events and issues facing Indigenous people. Watch now on the APTN News YouTube channel.